International law concerns norms that govern the international community. The international community is composed most importantly of states. Over the last century, international organizations have played an increasingly important role in the development of international law. The sources of international law define the rules of the system. If a candidate rule is attested by one or more of the recognized sources of international law, then it may be accepted as part of international law. The Statute of the International Court of Justice in Article 38 have identified the sources of international law, which is treaties, international customs, general principle of law, the teaching of most highly qualified publicists, and judicial decision. Other sources include unilateral statements, resolutions, and decisions of international organizations, and soft law. Based on Vienna Convention on the Law of Treaties 1969, treaty mean an international agreement concluded between states in written form and governed by the international law, whether embodied in a single instrument or in two or more related instruments, and whatever in particular definition. Treaties, also known as convention, international agreement, pacts, general act, charters, through to statutes, declaration, and covenants. All these terms refer to the similar transaction, the creation of written agreements whereby the state participating bind themselves legally to act in particular way or to set up particular relation between themselves. The 1925 Geneva Protocol prohibits the use of chemical and biological weapons in war. The protocol was drawn up and signed at the conference which was held in Geneva under the auspice of the League of Nations, and it entered into force on 8 February 1928. In order to understand fully the role of treaties as a source of international law, it is necessary to be aware of the rule concerning the creation and operation of treaties. Article 6. Every state possesses capacity to conclude treaties. Article 26. Every treaty in force in binding upon the parties to it and must be performed by them in a good faith. Lastly, in Article 34, treaty does not create either obligation or right for a third state without its consent. That is why treaties are more accurately described as a source of obligation under law. So, how about the other parties who do not sign and ratify in particular treaties? They are not bound by its terms. For example, North Sea Continental Shelf case, whereby West Germany had not ratified the relevant convention and was therefore under no obligation to heed its terms. In Article 38, refer to international custom as evidence of a general practice accepted as law. Judge Reed has described customary international law as the generalization of the practice of state, but the reason for making the generalization involve an evaluation of whether the state is fit to be accepted and is in truth generally accepted as law. The number of states participating is more important than frequency or duration of the state. Even a practice followed by a few states on a few occasions and for a short period of time can create a customary rule. State practice prevent the creation of a customary rule. Such inconsistencies cannot be explained away by saying that one type of practice is more important than another's, or that the practice of some state is more important than practice of the others. Practice is concerned. This includes not just the practice of the government, but also of its court and parliament. It includes what states say as well as what they do. Opinio juris is a belief in legal obligation, including states must accord immunity because they believe they have a legal duty to do so. The international court will often refer to the existence of opinio juris from a general practice, from scholarly consensus, or from its own or other tribunal previous determination. The court concluded, even if there were some state practice in favor of equidistant principle, the court could not deduct the necessary of opinio juris. The North Sea Continental Shelf cases confirm that both state practice and opinio juris are essential prerequisites for a formation of customary law. Generally, a treaty only binds the parties to it, while a rule of customary international law binds all states unless there is some local customary international law or persistent. The two sources will interact and will sometimes come into conflict.
General principle of law. General principles are used when the court realizes there is no law covering exactly the case, neither parliamentary nor judicial precedents then the judge will proceed to deduce the rule that will be relevant by analogy from the already existing rules or directly from the general principle that guide the legal system. The purpose of the general principle is to close the gap that might uncover in the international law and solve this problem, which is known legally as non-liquid. There are various opinions about the general principle of law. There are a few examples of general principle. 1. Reparations. Reparation is recompense given to one who has suffered legal injury at the hand of another. Compensation is usually money, but also refer to other material or goods given as an equivalent to make amends for a loss, damage, or injury when the restitution is not possible. Chozo case happened on 1982 between Germany and Poland. Next is equity. Equity is a set of principles constituting the value of the system. The tribunal agreed that equity formed part of international law and that accordingly the parties could rely on such principle in the presentation of their case. Its existence, therefore, as a separate and distinct source of law is at the best highly controversial. Equity also can be used in certain situations in the delimitation of non-maritime boundaries, where there is no evidence as to where a boundary line lies. An international tribunal may resort to equity. Lastly, res judicata. Res judicata is a matter that has been decided by a competent court and hence may not be pursued further by the same parties. For example, if you lose a case in court, then you will have to follow the res judicata and unable to press the issue again. The example for res judicata case is administrative tribunal case. The principle signifies that the decisions of the court are not only binding the parties, but are final in sense that they cannot reopen by the parties as regard the issue that have been determined of an exceptional nature specially laid down for that purpose. The teaching of the most highly qualified publicist. In the heyday of natural law, it was analysed that juristic opinions that were crucial, while the role of the state practice and the court decision are less valued. Those writers were supreme authorities of the 16th to 18th centuries and determined the scope, form, and the content of the international law. 1. Find that textbooks are used as a method of discovering what the law is on any particular point rather than as the fount or source of the actual rules. The fact that the court make use of writer work is evident by dissenting and separate opinion in which the workings are set out in more details and reflect the court's actual method. Judicial decision. Judicial decisions are not strictly a formal source of law, but in many instances they are regarded as evidence of law. A coherent body of previous jurisprudence will have important consequence in any given cases. Article 59 provides that a decision of the court has no binding force except between the parties in the particular cases. One still finds that the state in dispute and the textbook writer quotes judgment of the Permanent Court and the International Court of Justice as authoritative decision. International Court of Justice itself will closely examine its previous decision and will carefully distinguish those cases which it feels should not be applied to the problem being studied. It is not rare for international court of one type or another to cite each other's decision, sometimes as support and sometimes to disagree.
Other sources. First is Unilateral Statement, and it also known as a Unilateral Acts and Unilateral Declarations. Unilateral Statement is imposing the legal rights and obligations. It's also able to realize legal obligations and impose on oneself through unilateral acts. Not only that, legal obligations cannot be withdrawn arbitrarily, but in the sources, consideration should be given to those countries that has any special conditions of the statement relating to the withdrawn, the extent to which those who have such obligations and depends on those obligations, and the third is a risk that has undergone fundamental changes in circumstances. The examples of the cases is a nuclear test between Australia and New Zealand versus France in 1974. New Zealand filed the application to ICJ about nuclear tests. The plaintiff argued that nuclear tests led to fallout of nuclear waste in the ocean and constituting of their rights under IL. France responded by requesting the case be removed from court list. France maintained the view that ICJ was manifestly not competent and not respect this jurisdiction. The defendants did not submit a count of memorials, New Zealand initial applications, and therefore did not participate in any proceeding and did not appoint an agent nor file any pleading in regard to the case. ICJ declared this to be under international jurisdiction and rejected the notions to dismiss the case. Once the ICJ acknowledged its rightful jurisdiction, France declared all tests to be completed. French president gave a speech direct to Australian and claimed to have finished all nuclear testing in South Pacific. Justice of the court brought forward the sole relevance question whether language employed at any given declaration does reveal a clear intention. It is apparent international law under Vienna Convention on the Law of Treaties that obligation cannot be imposed upon a state without the consent of other parties. Not only that, in unilateral acts recognized under international law, the ICJ concluded that the French president and other official statements were sufficient for unilateral obligations. The intention of a single state to commit an act fast ceases and isolated action constitute a unilateral obligation because the acts carried out no longer affects any party subject to the act. Open statement of intention and actor bound according to terms oral obligation. It's not determined whether the statements are written or oral in the case of unilateral act, as both are considered binding in the international sphere of law. In the world of politics, economy, and technology, there is a need for a growing presence from international bodies to instruct and resolve unilateral obligatory dispute. There is currently an area of ambiguity on what constitutes a unilateral act. Therefore, disputes are unable to be resolved by individual actors. This case has helped formulate proper guidelines for the establishment of unilateral statement.
Resolution and decision of international organization. Resolutions, a formal expression of the opinion or will of international organization. For example, 2020 resolution in United Nations website. Let's take a look at the situation in Somalia resolution. As we can see, there are solutions for particular issues. The next thing is decisions, are another formal action taken by international organization. They are more focusing in procedural matters such as election, appointments, time, and place of future sessions.
Of law, also known as a guideline, policies, directive, and operational manuals. The purpose of soft law are to strengthen member commitments to agreements, reform international norms, and establish a legal foundation for subsequent treaties. Besides that, it also refers to the rules that are neither strictly binding in nature nor completely lacking legal significance. In addition, soft law is not legally binding but still important, and also do not require statutory authorization and not directly enforceable.
In conclusion, source of law must not be called as the authority sanctioning or enforcing a law. It should mean the agreement from which the law originates or from where the rule of action has come into existence. In the contemporary world, a law is made by legislation. Courts take opinion of famous issues like foreign decisions, morals, and principles via peace channel, which is assembly. Mainly, it is all about union. If there is no support or agreement, then there is no law adopted. Thank you.